Yeah, thanks. I think I know we're a bit short on time, so I just wanted to mention very briefly on pre-employment health checks. The intention here really is to make sure that people who are disabled are assessed objectively for their ability to do the job in question, and that they're not rejected because of the disability. The Equality Act looks at this in terms of two different sections, if I can put it that way. One is the issue before a job offer is made, and the other is any checks that are carried out once the job offer is being made. So just very briefly, under the Equality Act, employers are not now supposed to be making any inquiries about disability before the job offer is made. There are some exceptions to that. One is the issue that David mentioned already, which is that obviously you can make inquiries about a person's ability to come for the interview. So if you need to find out something about their disability in order to make reasonable adjustments to enable them to attend the interview, then that is permissible. You can ask questions, this is again before the job offer is made, for the purposes of monitoring. And by that I just mean monitoring diversity of applicants. You know, many employers will still have a diversity questionnaire attached to an application form. And that's still fine as long as you're not using that information for anything other than just monitoring diversity. Positive action is another exception. Don't propose to mention anything further about that. And then there is also an exception for an occupational requirement, although I think again that's probably not going to come up very much in practice. And that's where you're actually trying to recruit somebody with a particular disability for a job. For example, if you need a deaf-blind project worker who has personal experience of deaf-blindness for a particular role. National security is another exception. Again, don't think it applies to many people in the room. And the one which probably is more relevant is where there's a function intrinsic to the job that you need to find out about. So the example given in the Code of Practice is if you're recruiting scaffolders and you need to be able to find out at a very early stage of the process that the person who you're recruiting is able to climb ladders and scaffolding without any difficulty. But in that situation, the questions which you ask have to be very specific to the role. Once the job offer has been made, the job offer can still be conditional on the health check, but, big red flag, you still need to make sure that the health inquiries that you're making are relevant to the job. And once you then have that information, you're then under a duty to make reasonable adjustments to the role, or to consider whether you can make reasonable adjustments to the role, because of course at that stage you have then made the job offer. You can't just withdraw the job offer because someone's got a disability. I know that sounds obvious, but be careful the questions that you ask and make sure that it is something which is actually necessary for the role. And then once you have that information, be careful what you do with it and make sure that you make a reasonable adjustments depending on what information comes forward. The data protection issue, really the issue there is that the health information that you're collecting will be sensitive personal data. So that applies equally to job applicants as for people you've made job offers to and employees. So make sure that you have a system in place for keeping that information safe. Only people who need access to it should be able to have access to it. You need to get the individual's consent to process that sensitive personal data and make sure that they understand what data is being collected and what it's being used for, and just make sure that you've got the right processes in place. I'm then going to pass across back to David, who's just going to speak briefly on criminal record checks.
So ideally, if you want to find out whether or not an individual's got a criminal record, you should be asking towards the end of the process. However, in practice, most employers want to find out quite early on, even if they ultimately do their criminal records checks later in the process, once they've actually made an individual an offer. The general principle in the UK when it comes to criminal records is that so-called spent convictions, convictions which have expired, no longer need to be disclosed. There are, of course, some exceptions to that for certain professions, such as accountants and lawyers, also certain occupations, such as those working in the financial services sector, or working, say, as care home workers and that sort of thing, and also certain jobs involving working with children. At the moment, there are three main stages of criminal records checks you can get. There's a basic certificate, which only tells you about unspent convictions. There's a standard one, which tells you about both spent and unspent convictions. And then there's what they call an enhanced one, which covers not just spent and unspent convictions, but basically anything that's on the police database, however minor or however historic it may be. And just yesterday, the Supreme Court upheld an earlier decision by the Court of Appeal that that super advanced level where it's kind of, if you like, warts and all, anything that's on the police record, is actually totally disproportionate in terms of what's necessary, and that there ought to be some element of filtering. So the reason this came up was that there was a case where an 11-year-old had stolen a bike, and then many years later he had to declare this as being relevant in terms of when he was wanting to work as a football coach. And in a similar situation, someone who was caught shoplifting as a nail varnish in their teens, later, 8 years later, couldn't become a care home worker because of their criminal record. So the Supreme Court said this is actually disproportionate, and as a result, the Home Office is now rolling out some exceptions to this. So it's not this blanket disclosure, but there's disclosure relevant according to what the individual's job's going to be. Now, obviously, not every employer is going to be doing criminal records checks. It tends to be sector specific, and in particular, in the financial services sector, organisations regulated by the Financial Conduct Authority or the Prudential Regulatory Authority, those appointing individuals to so-called approved persons positions definitely need to carry out checks. There's no strict obligation for them to do so, but any failure to do so brings into question whether or not they're carrying out sufficient procedures to ensure individuals are, in the words of the Act, fit and proper to carry out an approved person role. And a key part of that assessment, which every recruiter in the financial services sector ought to be going through, is to be looking at the honesty, integrity and reputation of that person. And obviously their criminal record really goes to the heart of that. That's it in terms of pre-employment checks. I'll now hand over to Matthew, who's going to focus on the immigration checks needed before an individual starts work. Thank you.
Immigration checks before work starts are important. We know it's important because you've got exclamation marks all the way down the left-hand side, so that's your giveaway there. It really matters because, of course, it establishes your statutory excuse to a civil penalty for employing an illegal worker. And an illegal worker can be someone who doesn't have the right to work in the UK, or somebody who does have the right to work but not in that role, and with these conditions, for example, working hours per the contract. And the fundamental principles behind pre-employment immigration checks are about what, when and how to check, when to check, and most importantly, what you are checking. The civil penalty now has recently been increased to a fine of £20,000 per illegal worker, and that's not the only risk, of course. It's the reputational damage, possible discrimination, unfair dismissal claims from a worker who's been taken on in illegal circumstances. If you hold a sponsorship licence under the points-based system, there's a risk of downgrading and revocation. You could then lose all of your sponsored migrants. There will be the impact on business continuity, the risk of more employee claims if that happens. You can see how the follow-on can arise from just one mistake. And of course, as a manager, it's then all happened on your watch. So you've got the idea. You have to get it right. Getting it right minimises the risk, but getting it wrong doesn't minimise the risk, and furthermore, it can create new risks. So I'm just going to run quickly through how it all should work. First of all, what the check consists of. Do you know how to check? You're checking, of course, original documents, and they fall into two lists in the published Home Office guidance. A new Home Office Code of Practice was issued last month, and that should be the one that you refer to. There's the Code of Practice and also a separate document now available from the Home Office, which is specifically listing and illustrating documents that you should check. List A documents establish a permanent right to work. List B documents establish a temporary right to work, and you know then that that particular person, if they come into employment, is going to be subject to rechecking, now on expiry, by the way, not every year, as was the case before. There's a reduced number of acceptable documents in the new guidance, so it's important that you don't assume that a document that you used to rely on is still in the list. Always refer back to the list if you're not completely familiar with it every time you go through the exercise, and be aware that there are other new features as well. For example, if you're employing a student who's sponsored under Tier 4 of the points-based system by the university or college, you now need additional evidence before you employ that person relating to their student terms in order to have the statutory excuse. So the most common mistake there on the documents that you check are that you're actually looking at non-compliant documents, and therefore your checks have been ineffective. When do you do the checks? Well, before employment starts, and if that means effectively on the day that employment is due to start, you have to be ready to send your would-be starter home if you're not able to complete the check satisfactorily because for whatever reason you're not being presented with the right documents. You have to be fair and non-discriminatory in your approach, but also objective. So, for example, what is a reasonable time for one person to produce documents in the event that they're not able to do so on the would-be first day may not be for another. So there is some level of reasonableness that's expected there. And how do you do your checks? Well, you must conduct them in the presence of the new joiner. You must apply an even-handed approach, irrespective of known or assumed immigration status. So to come back to an example where you might be a bit more relaxed about checks because you think you know the people that you're dealing with, for discrimination reasons, you should do it evenly. Always check against List A and List B in the published guidance. When you copy the document that you're making the check of, make sure you've got a clear actual size copy. Follow steps 1 to 3 as set out in the Home Office guidance, and always be alert for inconsistencies, which may require you, again as set out in the Code of Practice, I haven't got time to go through all the detail here, what you should do if you are presented with an inconsistency. There's also a new Code of Practice on avoiding discrimination as you carry out your checks for legality. Those incorporate standard anti-discrimination principles along the line that Rebecca was talking about earlier. The fundamental underlying principle is to treat all new joiners in the same way, irrespective of any assumption or knowledge about nationality or immigration status. Don't make assumptions, therefore. A new recommendation in the Code is to carry out diversity monitoring, and it's very important, of course, to be aware that breach of the Code of Practice on Avoiding Discrimination is itself admissible in the employment tribunals as evidence if somebody then brings a claim about the way that you've carried those out or in some way related to it. So, assuming that's all gone well, you've got your new employee, you know that they are legal and that you haven't discriminated against them. I'm at this point going to hand back to Rachel to talk about integration.